All right, each of you will have 15 minutes to present your arguments, and the council will start up for 5 minutes, so please just. We're ready to stand for.
Good morning, may it please the court. My name is Michael Lewis. I'm the attorney for the appellants, Aaron and Wiggins. I'd like to request 4 minutes for a bottle of fire. The issue here is really, it's an FHA residential foreclosure. The issue is the plaintiff's compliance with the underlying regulations in that case. This case is one of many that's come before the court recently on March 19th. We had a similar issue in Wells Fargo versus Awadala. It's your case number 27413. And that issue, and Judge Whitmore was on the panel for that. The threshold issue for the court to determine was whether compliance with FHA regulations is a condition precedent for an affirmative defense. Heretofore, this court has come up to the line of saying at some point we need to rule on that issue, but as of yet, it's not been done. The reason why it's important in this case, as the court's aware, if it's an affirmative defense, then it's not part of the plaintiff's initial burden of proof. If they meet their burden, then the burden shifts and there's a reciprocal burden on the defendants to show that there's a genuine issue. In this case, there was no affidavit or testimonial evidence offered by the defendants, so in that case, the plaintiff could prevail. My argument in Awadala, and I'll make it again here, opposing counsel did an excellent job of arguing all the different districts' views on the matter, so I won't go any more into that. But from my perspective and my client's perspective, it makes sense that the burden of production goes with the burden of proof. The underlying note and mortgage require that certain notices be delivered. Underlying regulations also say that certain things need to be delivered. The borrowers aren't competent to testify as to that, so therefore should be a condition precedent. The burden of proof should go with the burden of production. There's two things at issue here. One is the sufficiency of the answer the defendant set forth in paragraph 13 and 14, where they argue that the borrowers didn't, or the plaintiff did not send in notice in conjunction with the parts of the note in the mortgage that required notice to be sent. But more importantly, in paragraph 14, that they didn't comply specifically with the terms of the note in the mortgage that required compliance with FHA regulations prior to acceleration and foreclosure, and specifically cited 24 CFR 203.606A, which requires that all conditions of that subpart have to be met. The two most prevalent that we've raised as defenses are 203.602, which is a notice of deficiency requirement, and then 203.604, which is the more familiar face-to-face meeting requirement. As to 203.602, I think there's two issues for the court to resolve. First is the timing issue. The regulation itself says that the notice has to be sent within 2 months of a missed payment. There's obviously some disagreement as to the timing of that. The affidavit submitted in this case, one of the two affidavits, the first affidavit in this case, attested to the fact that it was the defendant were in default for failure to make payment on 10/1/2011 or any subsequent installments. That means the notice would have had to be sent by the end of November. The notice that was appended to the affidavits in this case had a notice that was sent in the first week of December, December 6th. So first there's a timing issue. There's not compliance with that. The second is content, and as I put forth in the brief, 203.602 requires the notice to be sent in a form that's consistent with the secretary. I set forth in there references to mortgagee letters that say what has to be in a notice of deficiency, 203.602. That's a list. Our argument is with the actual notice that was proffered in this case, it doesn't contain all that list. Most importantly, there's a HUD brochure that needs to be inserted or included with that notice. And there's no evidence that the notice provided by the affiance, in this case, with the plaintiff, contain any of that pamphlet information. Moving on to 203.604, the requirements to have the face-to-face meeting have to be done within 3 months of a missed payment. The issue here is a notice that was sent, I believe it was in July of 2013, more than a year and a half after the alleged default for one payment. So, a threshold issue, there's a timing issue. And one can argue at least substantial compliance with 203.602 would only be a week off, even if the content of the notice of deficiency was acceptable. You can say, okay, well, at least that's substantial compliance because it was about a week off from the deadline. Here, it's a year and a half from when the deadline under 203.604 to send the letter by certified mail. So clearly, the timing compliance is not proper. And the timing is important because this is an FHA mortgage, and when you talk about FHA insurance, it's not insurance to the borrowers, it's insurance to the lenders. The lenders make these loans to people that otherwise don't qualify for loans, and in exchange, the FHA requires additional measures to try to prevent default. And as the court is probably aware, the more months of missed payments that there are before there's some net revenue, the more money that has to be made up, and the more difficult it is for borrowers to actually catch up, reinstate, or get a loan modification and continue staying in the home. So the timing thing isn't just some arbitrary type of bureaucratic decision. It's actually important to the whole resolution process before a deficient note goes into default. So in that case, that's an important characteristic. There was no testimony for Exhibit A7, which is their letter, that it was sent by certified mail. That's a clear requirement in 203.604. So again, that's another genuine issue of material fact. It still remains in this case. The letter itself doesn't talk about an interview or a meeting. The interview is what's called for in 203.604B. Elsewhere in 203.604 and C and D, it talks about a meeting. But if you look at A7, really all it's doing is saying, we're going to send someone out there. We'll give you a copy of the letter in case you didn't get it by certified mail. And we'll be available to pick up documents to help you with a loan modification. I mean, it's kind of like having a meeting with the postman to either drop off mail or to give the postman mail. Certainly, probably not the meeting or interview that's contemplated by the regulation. So really, for all those issues, I would argue that the plaintiff did not comply with 203.604, such that not only is it a genuine issue, but their proffer of evidence is such that they show non-compliance, such that this case should be reversed and judgment should be entered for the Wiggins on that. The final issue I want to bring up.
There was some language in the letter regarding the face-to-face meeting. Right after it discussed picking up documents that made some reference to so that these matters can be resolved, something like that. Am I right about that?
Well, I have A7 here. There's some bulletized language that I talk about. That they talk about. It says, our representative will show you his identification. It's a security issue. Our representative will give you a copy of this letter, but without enclosures. Noting that there's no enclosures with this letter that's proffered. When a representative comes to your home, please have copies of the financial information described in the enclosed checklist. No enclosed checklist. Ready for our representative to take with him or her. And finally, our representative will collect the financial information you provide and return it to Bank of America. If you haven't recently sent information to us, our representative will confirm that we have received it and if it is complete. So really, it's more of a transactional type of interaction more than an interview or face-to-face to really explain to the borrowers what their options are, what their liability could be, and to try to actually get them back into place. It's just basically a personal exchange rather than a FedEx or a mailing of loan modification documents. That's really all this letter is offering to the borrowers. The other,
You have 5 minutes remaining, you want to say that if you want to go on?
if I get 1 more minute.
Can you just take off your work off?
Right. But finally, the issue too about there is a provision in there that the face-to-face meeting is not only going to send a certified letter, there has to be an actual attempt, a reasonable effort to make at least one attempt to go to the property and have the face-to-face meeting. In their record, they reference a phone call that Wiggins has apparently made to the servicer saying they don't want this personnel to come out. It's not dated, there's no idea what time it is. And furthermore, if it's a year, if it's when the letter, somewhere around the time the letter was sent in July of 2013, it's so far out of compliance that any kind of waiver that phone call may or may not have represented really isn't having an effect on the case. So, if they have an electronic record, they allude to it, they should be able to produce it. Even if it's a screenshot of whatever electronic record there is, not just a simple naked affirmative that there's a phone call. And with that, I'll say personal thing.
Good morning. May it please the court, I'm Rachel Kuhn, and I'm here on behalf of the plaintiff at Bank of America. As Attorney Lubes already discussed, the main issue here is whether there was a genuine issue of material fact going to my client, Bank of America's compliance with HUD regulations and various notice provisions in the note and mortgage. This district has yet to make an affirmative decision as to whether they are, a condition precedent, which is the view that many districts, including the 8th district, our neighbor immediately to the north, take, or if it's an affirmative defense, which is the argument that the 2nd district has made in the Gogo case, which I cite in my brief. Regardless of how that issue is decided, if and when it's decided by this court, my client has submitted sufficient evidence that it's complied with the regulations and or that they don't apply in this case based on the pleading in the defendant's answer. In the defendant's answer, civil rule, if we're talking about a condition precedent here, civil rule 9C would apply. And it would be as long as they're pled generally, then it's the burden on the party challenging the compliance to challenge that with specificity and particularity. They need to cite specifically which regulations my client didn't comply with. It's not the job of the plaintiff to have to, guess as to a vague assertion that the requirements weren't complied with. Here, the
reference to 0.602 or 0.604?
Your Honor, they cite that my client did not comply with, specifically they state plaintiff failed to give proper and requisite notice of acceleration. The only one they specifically cite in the answer was 24 CFR 203.606A. At no point in their answer did they specifically cite to 24 CFR 203.602, which would be the HUD's notice provision, or 203.604, which is commonly referred to as the face-to-face provision. The only one that was specifically cited was that 606A. Regardless of this, we still met our burden of production here. If we had a burden of production, if that is not waived. With respect to the notice provision, it says 203.602 says the mortgagee shall give notice to each mortgager in default on a form specified by the Secretary, or if the mortgagee wishes to use its own form, on a form approved by the Secretary, no later than the end of the 2nd month of any delinquency in payment. The notice of default that was sent to Mr. Wiggins by my client specifies the date of the default, the monthly charges and other amounts due. It tells him there's a specific date by which he has to cure the default.
What was the date of the default?
The date of the default, the last payment received by my client was the October 2011 payment. That payment specifically was made on October 29th, or it was the September. They were due for October. They made the September payment October 29th.
I'm a little confused. Was the payment late?
Yes, Your Honor.
So you're counting the number of days from the date of the late payment as opposed to from the date that was in default?
Yes, Your Honor. There was a loan modification that was executed by the defendants on June 21st, 2011 that provided the first payment was due August 1st, 2011. They only made 2 payments under this loan modification before going into default once again. The first payment under that loan modification itself was late. It was made on August 29th, 2011. That was the August 1st payment. The second payment, which would have been the payment for September of 2011, wasn't made until October 19th of 2011.
But they were in default.
They were already in default.
Right, they defaulted almost immediately upon this new loan modification.
So how does the late payment impact the bank?
Well, if we're looking at the timing issue here of when this notice of default was sent, the regulations say that it has to be sent within 60 days. Most
Within 60 days of what?
of the default.
Well, you said they were involved immediately.
They made that first payment in August, that cured the August default. And then when they made that payment for September, that would have cured that default. They didn't make the October payment. So I argue that the clock didn't start ticking until they were in default for failing to make that October payment. And in this case,
They would have been in default for failing to make the September payment.
yes, Your Honor.
So then it would be 60 days from the end of September, not from October, per the regulations.
Yes, Your Honor, but there's also case law that holds, it's specifically Washington Mutual Bank versus Mahaffey. It talks about the lender's compliance with these timeframes, and it says that so long as the lender complies with these notice provisions, the timeframe isn't, there's the timeframe, they're not holding the lenders strictly to the timeframe. To do so would be unduly harsh to the lenders. It would cause the regulations to have too much force and effect. In Wells Fargo versus Philip out of the 4th District, they kind of hinted this. They said that there's nothing that prevents the bank that had an active foreclosure case and didn't comply with the regulations from dismissing the case, complying with the regulations, and then filing the case again. Certainly. No, Your Honor, it hasn't happened here. Actually, I believe there was a prior foreclosure case, and that's some of the delay from a 2011 default and face-to-face not occurring until 2013. I believe there might have been a prior foreclosure. I didn't come into this case until it got sent
So
to
you're saying something compliant,
Yes. With the banks are requiring compliance with the actual completion of these requirements, but the courts are holding that the timeframes, it's just a substantial requirement. As long as you do them, those timeframes are really a suggestion in the servicing requirements. So the fact that this notice of default wasn't sent until December wouldn't be fatal to the bank's compliance with the notice provision.
And what about the notice regarding the face-to-face meeting? We're not talking about just a couple of weeks later, we're talking about 7 months.
The notice regarding the face-to-face meeting, again, it says it has to be done within a certain, it recommends that regulations recommend that these should be done within a certain time frame after the default. However, the courts are holding that, requiring the banks to do this or be forever barred from proceeding in a foreclosure case would cause the regulations to be unduly harsh. As long as the bank complies with the regulations, then that is sufficient. Yes.
So they can do it the day before the sheriff's.
No, not because there would be obviously an active foreclosure and it's gotten judgment, gotten sale.
Yes, I apologize to you, but you're saying at any point in time whatsoever.
Prior to filing the foreclosure.
So with this one, with the face-to-face then, so you're arguing with the year and a half or whatever it was, that you gave them about that, you're saying that was still substantial?
Yes, because the bank did comply with the face-to-face requirements, and/or I argue that they don't apply in this situation. 24 CFR 203.604 is the specific provision. It requires a face-to-face meeting or a reasonable effort to arrange such a meeting. It defines a reasonable effort as a letter sent to the property and a visit to the property. That visit to the property is not the actual face-to-face meeting itself. That visit to the property that the statute discusses is part of the attempt of a reasonable effort to arrange the face-to-face. And in that letter that was sent to the defendant, it said that they were going to send somebody to the property. That person going to the property to collect the documents wasn't for the purpose of the actual face-to-face meeting. That was the reasonable effort of going to the property, knocking on the door, saying, hey, the bank would like to meet with you, and trying to get some documents at that point to facilitate a productive face-to-face meeting, a productive loss mitigation review. Holding a meeting when the bank doesn't have any documents or anything to review as far as the borrower's financials goes really isn't that productive. So what they want to do is get these documents and then have the face-to-face meeting, and so that it's a productive meeting where there may be a resolution at the end. That is the sending somebody to your house to collect documents. It was not the actual face-to-face. It was the part of the reasonable effort. Here, upon receiving the letter, the borrower called my client and said, I'm not interested in a face-to-face. Under the regulation, one of the kind of carve-outs here, a mortgagee does not have to comply if the mortgagor has clearly indicated he will not cooperate. Well, the borrower calling my client and saying, I'm not interested in a face-to-face, along with a pattern, an established history of getting a loan mod and not defaulting, I think would be a clear indication that he's not willing to cooperate with a face-to-face. And at that point, my client has no further obligation to try to arrange his face-to-face meeting.
When that phone call came?
The phone call came after he would have received that letter from my client saying, we want to send somebody to your property to collect the documents and we want to have a face-to-face meeting. No, that was part of the reasonable effort to arrange a face-to-face. He indicated to my client that well, I would argue that he knows it exists. If he received this letter in the mail that said, the letter said yes, it said we want somebody to come get documents, and then it also said, just find it here. It instructed him. It provided a phone number. It said to schedule the visit on a day and time that's most convenient to you, please call. And I gave another phone number, the same phone number again at the bottom. If you have any questions, please call. Calling that phone number and saying, I'm not interested in this, I don't want to do this, I think would be a clear indication that he's not willing to cooperate. And at that point, my client's obligation under the HUD regulations to attempt this face-to-face letter have been waived. They don't have any further requirement to do this. It's in the plain language of the HUD regulations.
What you said in the letter is that you want to come out and get some documents. And so what he is saying, if he says, I don't want to do this, maybe what he means is, I don't want to give you documents that I have. I'm not interested in having a face-to-face meeting to be able to resolve the foreclosure.
I believe my client's, he called my client and said, my client testifies that he indicated in an inbound call that he's declining a face-to-face meeting. That was in...
words, face-to-face meeting?
That's in paragraph 6 of my client's affidavit. It said that despite Bank of America's attempts to set up the face-to-face meeting, the records show that he indicated in an inbound call that he was declining the face-to-face meeting. And this is testimony that is not rebutted by the borrower in an affidavit or otherwise. He does not dispute that he made this phone call. He argues, well, we didn't say when this phone call was made or to whom it was made. He doesn't dispute that he made this phone call or that he declined it.
What I'm confused about is the language. Was the word face-to-face in the notice that goes out saying, we're going to come and get documents?
It's not expressly in the notice.
So then the borrower calls and says, I'm not interested in you coming out to get documents, or words to that effect. Am I correct?
Yes, he said,
So how do we conclude that that has anything to do with the spirit and intent of the regulation, which is we're going to lie people sit down and talk this over, and how does the borrower know that that's what your letter intended?
the spirit of the regulation, Your Honor, is at the end of the day to try to get the parties together to reach a resolution and hopefully keep the borrower in their property if that's what they wish to do. That's the spirit of the regulation. And this letter makes it pretty clear that they want, it says, as your home loan servicer, we want to work with you to determine the best option. We want to help you stay in your property or discuss the options with you. We need to get the documents. And in this case, quite frankly, this borrower should have already been familiar with the process. He'd been through one prior loan modification. It says, when the representative visits your home, we're going to collect paperwork so that the bank can review you. If he calls and says, I'm not interested in this meeting, I don't want to do it, I think the intent here of this letter is pretty clear that we're trying to reach a resolution. That's the intent of the HUD regulations.
You're down to 20 seconds.
Okay, unless you have any other questions, I'm finished. Thank you.
Thank you very much.
203.606A, which was referenced in the answer, starts by saying this: before initiating foreclosure, the mortgagee must ensure that all servicing requirements of this subpart have been met. If it's the plaintiff's allegation that every particular one of those has to be done, then that's a pretty high bar for specificity and particularity in the 9C. Furthermore, when they did their MSJ, without any other prompting from the borrower, there was no discovery exchange or anything like that. They tried to show compliance with the notice of deficiency requirement and the face-to-face meeting requirement. That was proffered in there too. Two affidavits were put in this case. 203.602 says, the mortgagee shall give notice to each mortgager in default on a form supplied by the secretary, or if the mortgagee wishes to use its own form, on a form approved by the secretary no later than the end of the second month of any delinquency in payments under the mortgage. The testimony, not the argument of counsel, the testimony is from paragraph 7 of Brenda Swinton's affidavit. It says, borrower defaulted on the note by failing to make payments due for October 1, 2011, or any subsequent installments.
But there was a payment made after that date.
That's correct.
Right.
But because there were some payments that were behind already, that got credited to a previous.
And your position is that late payment does not defeat the argument that the default took place in the 60 days or whatever it is, start from default, not when you receive a late payment.
That's correct. It's when the payments are actually attributed to the account. Because under that theory, if they made a payment 5 months later, the 2-month window, they don't know when the next late payment's going to come. They need to send that within 60 days of that notice provision. We talked about the not requiring a strict interpretation. These are must and shall type regulations. It's not should or may or it would be nice if. The operative words are must in the regulations. We talk about forever bar. There is nothing in the mortgage or the federal regulations that say if you don't comply, you can deaccelerate the note with the missed payments at the end and let them start paying the mortgage. The fact that they don't want to do that because maybe they might lose their FHA insurance or for some other reason, it's on them. But there is no legal requirement that forbids them from deaccelerating the loan, taking the missed payments, putting it at the end of the loan, and letting the borrower start again. And then if the borrower makes a subsequent failed payment, you have a new default date and you can try again. This is one of those things where you're a year and a half late and you can just do it, do a CYA and be done. The time limits are important. They didn't make the time limits for that reason. Not only should the court reverse ruling of the county police court, which should find that there should be judgment in favor of the borrowers here and Wiggins. Thank you.
Thank you. The court will take the matter under advisement, issue a written opinion